Very good evening to all the viewers and my friends. I welcome you on behalf of Vidat Legal. I'm Advocate Pravartak Pathak. Recently we have the National Education Policy 2020 that Cabinet Minister approved. And since then, there is a lot of debate, a lot of discussion going on with respect to national education policy. Of course, this national education policy will impact to the legal industry as well, and there will be a lot of changes so far legislative structure is concerned that is expected when this policy will be implemented. There is also another angle with respect to national education policy, as it may affect the existing structure of the legal education. So, need to understand what are the aspects as to implement this NEP, as to understand this national education policy, and how will impact to the current legislative structure as well as the legal education. Today we have Dr. Anil Saharabudhe, who is the chairman of AICTE and also played very important role in shaping this national education policy. I request Advocate Akash Kotecha to introduce our today's guest. Advocate Akash Kotecha. Advocate Akash.
Thank you, Pravatak sir. Myself, Advocate Akash Kotecha. I am here to introduce today's speaker, Professor Anil Saharabudhe. Professor Anil Saharabudhe did his BE in Mechanical Engineering in 1980 from Karnataka University, securing first rank and a gold medal. He did his Masters in 1982 and PhD in 1989, both from Indian Institute of Science, Bangalore. In between, he had brief stints of working as a scientific officer in IISc during 1983, and engineer trainee in Tata Consultancy Engineer. Before starting his teaching career in a newly started Northeastern Regional Institute of Science and Technology, Itanagar, Arunachal Pradesh, and again newly started Indian Institute of Technology, Guwahati from 1995 onwards. He had responsibilities such as Head of Mechanical Engineering, Chairman, Library Committee, Chairman JEE, Dean Academic Affairs, and Deputy Director till 2006. He thereafter joined as a Director of College of Engineering, Pune on deputation and turned around his institute, bringing in the reckoning amongst the top 15 to 20 institutes in India. He joined AICTE as a chairman in 2015 and turned around the entire functioning and made it a more vibrant facilitator organization than being a mere regulator through a slew of reforms and programs. He is a chairman of Basic Science Research Committee of UGC and member of many MHRD committees. He has been associated with several professional societies and is fellow of ISTE, IET, and INAE. He is a recipient of Praj Entrepreneur Award 2011, Jeevan Gaurav Puraskar, which is also called as a Lifetime Achievement Award 2019 of MIT World Peace University, and Mahatma Gandhi Leadership Award 2009, amongst others. Sir, it is our pleasure to have you on this platform, and I welcome you all on behalf of the audience and Vidat Legal. Thank you.
Thank you, Akash. Now I request Professor Anil Saharabudhe to have a word with us.
Thank you. First of all, Vidat Legal, as well as my friend Pravartak Pathak, Advocate Akash Kotecha, both of them have introduced the topic in a way that the new national education policy has been announced. It was approved by the cabinet, and we are all aware that education touches almost every home. It's very rarely that in any particular home there could be a gap of about maybe 7, 8 years or 10 years that no one is going into the education system. Either the person himself is doing his master's PhD degree, or his father or mother, etc., may be teachers, or your son, daughter, grandson, granddaughter will be either in the college or in the school or in the nursery. And therefore, education touches the lives of almost every citizen. Probably it is the only sector which touches everyone other than probably the finance, economy, where everyone wants to have some living and therefore earning, and therefore finances are concerned. But other than that, probably the only other sector which touches everyone is education, not even health. The reason being, there are people who are quite hale and hearty, they don't require to go to the doctor throughout the lifetime. In fact, many of them say that I did never went to the doctor. But no one would say that I have never gone to a school. And therefore, I think education is very significant and important. And sweeping reforms have been talked about in this particular education policy, a draft education policy of which was prepared by Dr. Kasturi Rangan, the former chairman of Indian Space Research Organization, along with other 7, 8 members of the committee who had discussions with almost all the stakeholders, right from the village panchayat to the district level, to the city level, to the states, to various segments of the society, whether it is in terms of educationists, whether it is in terms of the people from the industry, people from the various academies like Indian Science Academy, Indian Engineering Academy, Indian Social Sciences Academy, law. Everyone they conducted several workshops, and based on all of that, this is like this still form of the thought process that the entire country has gone through in the last 4 or 5 years. In fact, it was long awaited. A committee was set up way back in 2015, and then it went on for about a couple of years. The committee was headed by then the earlier retired IAS officer. That report came in and it was not acceptable. So one more committee was constituted. It went through for 2, 3 years, and finally a distilled form, what in our Indian languages we call nectar or amrut, has come out, and therefore we must all adopt this and then start operating on it. A brief history: if you look at the various societies and also various types of bodies who regulated education as such, there are hundreds of them. And in particular, in India, this is one of the most complex systems ever imagined by anyone. We have legacy of the British on one side. On the other side, when we got independence, we also started moving in the same direction, and we had several acts which came into existence, and some of them were already in existence. I'll just give few cursory examples to get a feel of it. For example, there was Institution of Engineers, which was by a charter which was created by the British government, and it continued to conduct some examinations similar to what today also we conduct examinations for chartered accountant, company secretary, and so on. They are not officially universities who are authorized to give degrees, but they conduct examinations for getting members on board. So they are called as associate member and member of the organization. And once you pass those examinations and become a member of that charter, you are treated equivalent to a degree holder. So I think that is one very extreme phenomenon which existed, and many other offshoots of Institution of Engineers, which is the original one, came into existence. Some of them maintained quality, some of them not, because there was no regulatory framework for controlling and managing them. So this went on. On the other side, when I am talking about engineering education, in 1944, through the CADE, there is a Central Board of Education which is headed by the Minister for Education, Minister for HRD, which was there in existence way back in 1920s. It went off sometime, again came back, and that committee suggested, CAPE committee suggested, that there must be a regulation of technical education, and therefore AICTE was formed, but that was sort of an advisory body. CABE is also an advisory body, and one advisory body advising that there must be another advisory body for especially higher technical education. AICTE's birth took place. But having taken the birth, it had no legal teeth, and therefore it was advising to the ministry, then Ministry of Education. Again, it got converted into Ministry of HRD. Now, in this particular education reform process, in the new policy, it is again back to the Department of Education or Ministry of Education. So this particular status which changed had its effect in 1987 when there were a huge number of private colleges started coming in and a lot of commercialization of education began. The government rose to the occasion and decided that rather than having an advisory body called AICTE, the same AICTE body should be converted into a formal association or organization which has statutory powers, and that's why a legal provision was required to be made, and therefore AICTE Act was promulgated in both the Houses of Parliament in 1987. Post that, entire technical education regulation has fallen in the hands of AICTE. But there are very interesting things which have happened in the process. We have UGC, University Grants Commission. The Act was passed in 1956 of independence, and it controls basically universities. Its name suggests that it is a University Grants Commission. So it is expected to give grants, and still it also regulates the universities because it is UGC which has the mandate for taking care of universities of all variety, whether they are what are known as central universities promulgated by an act of parliament, state universities promulgated by the state assemblies of different states, private state universities. These are all new models which have emerged in the latest phenomenon of the late 20th century, somewhere around 90s. Big number of state universities came into existence. But prior to that, in the 1980s, there was a sudden spurt of private engineering colleges all across the country. This phenomena was earlier restricted to Karnataka. Karnataka was the first state to start with private engineering colleges way back in 60s, 65, 66, etc. In fact, one of the first private medical colleges also came from Karnataka way back just after independence, which is known as Manipal Medical College, which you all know that it's one of the famous medical schools. But nevertheless, the private entrepreneurship coming into education spread to then from Karnataka to Tamil Nadu, Andhra Pradesh, then slowly to Maharashtra. All of these institutions in Maharashtra, Karnataka, not Karnataka, Tamil Nadu, Andhra Pradesh came post 1980s, whereas Karnataka had from 60s. This further spread into entire width and breadth of the country, length and width of the country, from somewhere around near to 95s, 2000, somewhere around that. And that is the time when even private universities started springing up. So UGC Act regulates university education. AICTE Act regulates other than universities, any institution which is affiliated to a university but is running technical programs. That was being done by AICTE through the Act of Parliament. But please remember, in the various domains that were specified in our AICTE Act, engineering, technology, pharmacy, architecture, management, hotel management, applied arts and crafts and design is later added, is included. So there is Council of Architecture, still architecture provision was made in the Act. There was a Pharmacy Council of India, still pharmacy was mentioned in the AICTE Act. And therefore, from 1987 onwards, these two bodies, Pharmacy Council of India, which was there in existence from 1948, soon after independence in the form of an Act of Parliament, continued to regulate pharmacy education, and since AICTE Act had pharmacy mentioned, AICTE also continued. Similar is the case with the architecture education. Council of Architecture existed from 1972 and AICTE came in 87. So both of them continued regulating architecture education. The 1987 Act of the, the AICTE should have at least either not mentioned architecture and pharmacy so that it would have been continued to be regulated by those respective existing councils, or while enacting this AICTE Act, it should have been very clear that here afterwards the previous acts are overridden and therefore Pharmacy Council of India and Architecture Council do not have anything to do with those two education sectors and AICTE will do everything. Since this statement did not exist, both continue to operate and sometimes because of differing norms set by both these bodies, AICTE gets some of these norms of its own and we approve, Pharmacy Council or Council of Architecture may not, and the vice versa. Sometimes they approve and then AICTE does not approve. And then the colleges are left in the lurch and then they will go to the legal remedy. And sometimes the cases are heard and then they are in favor of AICTE, sometimes in Pharmacy Council, and this was going on. I think this was a very, very drastically very bad part which went on. Secondly, UGC, which controls universities, as I said, there are state private universities, state public universities, central universities. There is another breed of universities called as deemed to be universities. These are actually not universities, but they were institutions for a long time standing. And ultimately, because of the good processes that they follow, and based on their application, MHRD, UGC sends a committee, and after vetting that, the processes are almost similar to that of university. They have control of examination, registrar, they are in a position to frame their own curricula, they are able to manage everything, and therefore, they are given full autonomy to graduate upwards to be treated equivalent to deemed to be university, that is university, who can offer degrees. There is one lower level also under University Act, that is UGC Act, which is called autonomous colleges. These autonomous colleges are those who continue to be associated with the university with whom they had started off their journey right from its inception. But not only that, they, because of their again good processes being followed, when they apply for autonomy, a university grants commission committee visits the institution, looks at all the processes and admits them to be the autonomous institution. When we say autonomous, they have liberty to frame their own curriculum, they have liberty to follow their own teaching learning processes, they have freedom to have their own paper setting by their own faculty, or they can invite any external faculty they wish. And finally, after the conduct of examination, evaluation of the answer books and declaring the results, the only part which they do not have authority is of actually award of the degrees themselves. Since they started their journey with affiliation to a university, that umbilical relation still continues and they are required to send all the reports to the university and university finally gives the degrees in the convocation of the universities. They can have a internal graduation ceremonies, but not the convocation. Convocation authority vests with only the university to which these colleges are affiliated. And where the colleges are not autonomous, and a university may have hundreds of colleges who are non-autonomous, the entire responsibility of the curriculum, the teaching learning processes, the internal evaluation, the external evaluation, the end semester examination, the question paper setting, results announcement after evaluation, everything rests with the university. The colleges have a limited role of conducting some internal assessments and giving some 20% of the weightage of the entire marks to the university. The university conducts the examination worth 80% of the marks, and then the student is either declared passed, failed, and then whether it is allowed to continue next year or not will be decided by the university. So, under the university, there are affiliated colleges, again of two types. One is non-autonomous and one is autonomous set. The autonomous set is very close to that of a deemed university. Probably for simplicity, we can say that is the route through which one can become a deemed to be university. Once you get autonomy, you have all the processes which you can follow, but still the degree is awarded by the university. But by conducting the processes very well, you can now think of graduating upwards to a higher level and then claim that you would like to be a deemed to be university and making an application committee visiting and observing your phenomenon of processes, they may award you the deemed to be university status. So there is another variety of universities which exists. Now, interestingly, deemed to be universities are actually not the university. They are deemed, and therefore they are treated in a way under AICTE Act as institutions, being not universities. And AICTE Act has every permission to delve into the matter of non-universities, either a college affiliated to a university or a standalone institution which can award diplomas. They are all regulated if the program is of technical education. Now imagine an institution which is a deemed to be university. Suppose it is doing a program of say architecture or pharmacy. First and foremost, since it is a deemed to be university, grant of permission being given by UGC, one of the regulatory bodies would be UGC. Since they are running either pharmacy or architecture program, they are again to be reporting to the Architecture Council, that is Council of Architecture or Pharmacy Council of India. And since AICTE Act also has pharmacy and architecture, AICTE also will regulate. You imagine the plight of these kind of institutions who, in order to continue their programs in pharmacy or architecture, they have 3 or 4 bosses. And independent of that, there could be state government intervention, there could be intervention by the central government if they are required to have certain quality framework in terms of getting funding from the World Bank funded TechWip project, another area. So I think the multiplicity of regulatory bodies having overlapping functions was in a way very dangerous thing which was happening, and therefore sometimes one can get away with stating that the other organization has given approval, so who are you to ask me the question on one side, and on the other side both the organizations trying to stifle the organization that is an institution. So I think both extremes used to happen, and that is where in the context of all of this new education policy has come out with a single apex body which will regulate the entire education sector in the higher education. But they made again 2 exceptions in the recommendation. I don't know, finally the government has accepted the entire education policy itself, so it will go through as it is. So 2 sets of educational institutions for given this waiver come out of this new education policy with a single regulatory body or single apex body is the medicine education and the law education. It may have its own reasons. They must have had several meetings with the stakeholders of medical education and law education and came to the conclusion that these 2 should be kept out of the ambit of the new regulatory body which will be coming into existence. So this is the backdrop. Now, therefore, the legal luminaries were there participating in this particular webinar. I think they should not be excessively worried that what will happen to the legal education and whether there would be any change in that. As on today, certainly not, unless the courts intervene and state that when everyone is under one umbrella while you are segregating these 2 domains, that's a different matter. But otherwise, government has accepted currently the new national education policy, which allows regulation to be done for all variety of institutions by a single regulatory authority, but not medical education and not the legal education. Medical education already earlier MCI Act has been already completely reformulated and therefore quite a stable type of processes are already inbuilt, and therefore probably government did not feel the need of that. In terms of legal education, there could be another reason, but these two are exempted. But why we are talking about this in this seminar or webinar today at late night, 8 o'clock without legal, is although this regulation is not going to be affecting the legal education, legal luminaries are going to be involved when these acts come into existence. The policy is only enunciation of the wisdom of that committee, which went into great detail and found those overlaps, and therefore decided that they should be done away with, and therefore a new norm was established or required to be established, and therefore recommendation has been made, which is expected by the Union Cabinet. Now, formally, in order to give effect to that, there must be legal provisions which have to be made. Now, I come to this single apex body, which has 4 different components, and I will describe each one of them first, and then how an act has to come into existence, and which will take care of all of these issues. The first one is the regulatory framework. We have, as I said, I explained only 2 regulatory bodies so far in great detail, that is UGC and AICTE. But there is a regulatory body for teacher education, which is called NCTE. Then we have already discussed in some length about MCI and similarly Bar Council of India for legal, for medical and legal education, Council of Architecture, and I have discussed about other regulatory bodies like Pharmacy Council, there is a Nursing Council, there is Dental Council, and you will have Distance Education Council. There are many councils like this, each one having separate entity and separate identity, and they will keep doing regulation of that respective type of education. Now, all of that being brought under not just one regulatory body, with someone even above that, and that is what is called as Higher Education Commission of India. So the entire gamut of higher education is being dealt by HECI, Higher Education Commission of India. Under that, these 4 verticals. First vertical is regulatory one. The name I don't recollect now exactly, but the regulation function is that of giving approvals to the new institutions coming into those domains, or existing institutions to verify that they meet standards and norms, and give continuation of approval, maybe for 1 or 2 years, or maybe for a longer duration. This is the task which will be assigned to the one vertical of the new apex body, that is Higher Education Commission of India. Second body is the funding body, which is again a sort of a council which will take care of funding. Because we observe that UGC also funds several universities, salary of the faculty and staff on one side, research proposals on the other. AICTE also funds many institutions in terms of research, in terms of faculty development programs. So all of these funding functions of different agencies of the government will come under one umbrella, and that is the whatever you call the council, which will take care of all the fundings for the different institutions. They may be government or private. In government institutions, a substantial amount of funding is given. In private institutions, because they charge a high fee and then are able to maintain their own, infrastructure and the teaching learning process, they are given only normally for research purposes, which is useful for the entire country. The third part, the third vertical, is about accreditation. Today we have 2 important accrediting bodies. One of them is NBA, National Board of Accreditation, which has been a signatory of the Washington Accord for technical education, in particular engineering education. So Washington Accord is the accord signed by initially some 9 countries, now expanded to 21 countries, India being at only 6 years back. And every 6 years, the review takes place, and some of these will be weeded out, or some of them will continue. And there are difficulties in continuing. We are happy that our performance in the first 6 years has been fantastic, and we have got permission to continue accreditation and have the signatory status of Washington Accord for the next 6 years. And this decision was taken unanimously by all the 20 other countries which are part of the Washington Accord. There are many in the pipeline. Gradually, the strength of the Washington Accord signatory countries is growing. But what is important is the graduates from accredited institutions by the national accrediting body, that is National Board of Accreditation. Those graduates are treated as equals in all those countries who are the signatories of the Washington Accord. For example, I will give few countries which are all up, very advanced countries. For example, USA, Canada, UK, they were all initial signatories, including South Korea, Japan, and then Australia, New Zealand, Singapore. These are all almost initial countries, and they have now further expanded to 21 countries. So in all of these 21 countries, if an engineering graduate from India, it's a college which is accredited in those programs, and this NBA accreditation is not institution-wise, it is program-wise. Suppose I'm again repeating, a mechanical engineering student from a X college, which is accredited for mechanical engineering. If he goes to any one of these 21 countries, he is treated as an engineer equivalent to in those countries. That means for getting licensed to either practice or for doing any job in those countries, a person graduating and from a program which is accredited by NBA is treated on equal terms. I think very, very fundamental. Any other candidate from any other institution which is not accredited by that NBA, if he travels there, he will have to undertake another examination, maybe interview, and only then they will allow you to either practice or conduct the job. I think this is very, very fun. If you're from those countries, companies, or those countries' educational institutions or organizations. But if you're working for an Indian company over there, probably that problem doesn't arise. But still, I think someday this may also be possibly a problem. Very recently, there were cases from Kuwait and UAE that engineers who have been working there for more than 15-20 years, their visas were not renewed for the simple reason that they wanted to weed out these people who were not from the programs which are accredited back in India. And this fell on some of the IIT graduates as well. IIT graduates who were working in Kuwait or UAE, they were termed as non-engineers or technicians if they want to continue in their country, and not allowed to be operating as engineers with a lot of perks that they enjoy in those countries, including maintaining a car license. There are so many restrictions otherwise technicians. So engineering graduate, although had done engineering from a formal recognized college, recognized university, and had experience of 20 years, very useful to that country, has contributed immensely. Still, they negated their continuation of visa on the simple ground that their engineering degree from where they have got it, that program was not accredited, and now also that college has not got that accreditation. And therefore, there is a great value for accreditation. On the other side, there is what is known as NAC, National Academic Accreditation Council, which is a program not based accreditation, but it is a institute level or university level accreditation. We don't go program by program. Overall, the performance of the institution is watched, including all the departments and disciplines, and then accreditation is given. So I think these are two different types of accreditation processes. Normally, NAC accreditation is done by non-technical institutions and normally by universities. I think this is for the accreditation. So the new education policy envisages that under the single apex body, there will be the third vertical, which is called as accrediting body, accrediting council. The last vertical which the new education policy talks about is about setting of norms and standards. And it is here that many of these existing various types of organizations, which I mentioned earlier, like Pharmacy Council of India, or the Nursing Council of India, or our Architecture Council, or for that matter, Institution of Engineers, which I started off with in the beginning, all of them can contribute to this particular council under the apex body for setting of norms and standards, for giving advice on what should be needed, what is required to be done in the future for continuing that type of program in the universities and colleges. For example, PCI, Pharmacy Council of India, can give a very robust advice to this particular body, which is a standard setting body, that if a person has to graduate as a pharmacy graduate, he needs to undergo following 1, 2, 3, 5, 10 courses. He must have ability to discern between different types of, the medicines that are prescribed by the doctor. Then, depending on equivalences, he must be able to take a judgment even in the absence of a doctor. If the prescription is for X medicine, if the Y medicine has same content, can he be able to give it? I think this is a very detailed knowledge about how it affects the different parts of the body as far as the medicine is concerned. They must be aware of that. And that is why in the curriculum, what kind of exposure is to be given to the students is very, very significant, whether it is in terms of internship, whether it is in terms of projects. And this is not true for only pharmacy council or pharmacy education, it is true for engineering education. It is true for medical education. It is also true for legal education. But in the ambit of the new act which is to come in, I think these are the various issues which have to be dealt with. Second issue which the act has to deal with is these existing councils and commissions with some separate powers which they were building till today. How do you dissolve them? Will they become part of the new body, including the employees of theirs, or will it be only the employees taken in and the body is totally going to be dissolved? I think these are the kind of issues which will come in. The third one is the legacy in terms of whether it is the property which has been existing with these organizations on one side, and the processes through which the approvals were granted by these bodies. Now there is a new body, whether all the approvals of the past will be carried forward, or whether there will be a review exercise to be done by the new body in all these domains. I think these are very concrete and very important aspects which the new law or the new bill, when it is brought to the houses of the parliament, Rajya Sabha and Lok Sabha for passing, there is a requirement of the input from the legal profession. And that is also important because post this, if there is someone who is aggrieved by the whole process and he had the approval and some other body has come in and it is not giving the approval, such organizations may file a suit in the court of law, and therefore the legal luminaries have to come forward and see that such cases will not arise in the first place. If they arise, how do we require to handle them? I think that is where the legal professions, all the advocates who are there on the panel now, right now, and watching me and talking to you all, are having a significant role to play, right from High Court to Supreme Court. I think I have dealt with in almost great detail most of the phenomena. I wanted to prepare a PowerPoint presentation, but unfortunately, time, so many webinars, offhand, online, reached home and immediately started off with this, with some teething trouble with our internet. I hope I have carried the message that is required to be carried to the advocates.
Definitely, sir. In fact, it was a very good presentation and a very elaborative discussion on the national education policy. Sir, meantime, I have a question. In fact, I must say before asking question to you that we are really grateful that you rushed from your office and immediately came live. Uh, so the question to you is this: that since this entire policy starts from the education for the children from the age of 3, when we think about the legislative process starts from the constitutional amendments. Now, so the Article 21A, which deals with the fundamental right to education, the Article 21A provides the age between 6 to 14. Is there possibility this right to education as a fundamental right get amended because of this policy?
Yeah, I think quite likely it may be required. So once you have said that the education should start at the age of 6, and now you want to do it from the age of 3, so there could be a possibility of requirement. But interestingly, what has been done is it does not talk about formal education starting at that age of 3. This is actually very informal way, which has been integrated from what already exists in some. Uh, Although formal education starts from the age of 6, and that is what we call class 1, class 2, and we go up to class 10, and we have a 10 plus 2 system before entering into a proper university education, which is BA, BSc, BCom, LLB. LLB, of course, can be integrated, can be after BSc, BCom also, or in terms of B Pharma, B architecture. All of that is after 10 plus 2. Our starting point is 10 plus 2 for university education. So the 10 years of education for matriculation and post-matric, that is 2 years pre-university education, is after the age of 6. So 6 to 12 years, that is 18 years one has reached by the time he actually enters into formal college or university type of education. This is what is there existing today. But when you talk about the 5 plus 3 plus 3 plus 4 system, starting at age 3, ending is again 3 plus 15, that is 18. So the class 12 level today and later will remain the same. So only the starting point which has been brought down from 6 years to 3 years. Now, as you rightly pointed out, it can be viewed in two different ways. Since you have brought it down to the age of 3 instead of 6, maybe an amendment under section 21 may be required, is a possibility. The other possibility is we already have nursery, low KG, upper KG in most of the cities when children are sent to these organizations in their nearby homes, because they normally don't go to a far off place. These are nearer home, and at the age of 3 you start with a nursery, then lower KG and upper KG in some way. And in the various rural and other areas, we have what is known as Anganwadi, and formally Anganwadi also takes care of all these children of the lower age. So in some way they are going to a location other than their homes and indulged into some kind of learning, some kind of education, but which is absolutely informal. There is no examination, there is not much of a pressure on learning some script or understanding something and taking an examination. None of these things exist, but children are made to get adjusted to becoming social, come and meet with other children of the same group, play games, and in the process of doing some activities, which are many cases, you have paper and scissors given to you, you have been given a small sketch pen, you draw anything you like. I think a very, very informal way of learning. Now that informal way is slightly being made formal, but still informal, because you say in this policy also that out of these 5 years, 3 years are kept separate, and the actual standard 1 and 2 is talked about in the last 2 years only. So I think there is not much of a difference, but only integration of existing infrastructure of the Balawadis or the our nursery and upper KG, lower KG to be integrated with the school education. That's all what is happening.
So before moving to the next question by Varada, I have one more question. Since you just mentioned about the infrastructure, so as a lawyer, we see, especially in June and July, when the academic year starts, there is a lot of litigation with respect to the infrastructural aspect, recognition aspect. Now, this policy speaks about the complete capping on the education fees on various courses offered by the different universities, including private universities. So, will it affect the role of the private university?
No, I think when the regulation of fee is talked about, it has two elements to that. First element is, in our country, all the time, we have considered education as what we say in our Marathi or Hindi or any language, including Sanskrit, is Vidya Dana. We donate our Vidya. That means we don't expect anything in return. Of course, there are examples of Guru Dakshina being given at the end of the graduation, not at the starting point. And therefore, the entire philosophy is not for profit. And that's why who are allowed to start the institutions? We used to have institutions to be started by trusts or societies, or later Section 8 and Section 25 companies, which are again not for profit. And so, therefore, education per se itself as a policy always has been not for profit. When it is not for profit, there must be a ceiling on the fees that the institution can charge to the students, that is stakeholders, because there is some amount of expenditure which is based on certain regulations also, that you have to maintain a ratio of faculty to students of so much. If you have 25 students, you require one teacher, and the salary of the teacher has to be borne. The pay commission gives higher and higher salaries after every 10 years. So to maintain the faculty salary is one. The infrastructure which is built maybe by taking loan from the bank, therefore interest to be paid. You also have possibly the maintenance of the infrastructure which is built. Then there are some equipment in the laboratories and workshops in the case of some of the education, not necessarily everywhere. And today, of course, every institution will have a computer at least, and every computer will become outdated in 5-6 years' time. Therefore, you have to buy. So I think all of these expenditures, if they are calculated and the number of students that you admit in your institution is known, if you divide the total expenditure by the total number of students, per capita expenditure per year will come out. And in order that we take care of some of the exigencies, maybe sudden some requirement will arise, and some purpose there with every institution for that patch. So if there is a 5%, 10% additional amount allowed to be charged, there is always going to be some amount of ceiling. And however best quality education you talk about, it cannot charge 1 crore rupees per annum. It may require about a lakh of rupees, but not 1 crore. So if someone says that my institution is one of the best in the world, so I would like to charge 1 crore rupees per annum as the fee, and which is not permissible both by law and by act which is there, and therefore some kind of fee regulation is required. But that does not mean you will be forced to charge certain fee. Probably an upper ceiling or upper limit on the fees based on the calculations which are narrated right now will have to be worked out by some higher level committee, maybe some retired justice, some retired officers, retired educationists. They can be a form of a committee who will deal with every type of education, and from year to year they may change the amount also. This year the maximum fee limit could be say 1 lakh, next year it could be 1,10,000. So based on realities, ground level requirements, a fee limit can be specified. Now, below the limit, each institution, depending on what they offer, can charge what is required. Someone may be very miser and will be able to manage with lesser resources, so he will be able to charge less and attract students. Someone else will charge the upper limit still, which is given. I think therefore this part should not be a problem. The problem existing now, you talked about the infrastructure verification and litigation comes because the inspection branch, this because of inspection. In 1991, we often talked that economy was liberated, Lakshmi was liberated, and education is still in the clutches of the regulators. That's what is often talked about. I'm a regulator, but I'm saying this. So therefore, if the basic standards norms set by the new committee which I talked about under single regulatory framework that affects bodies fourth pillar sets the standards and says that this is all what is required. The institution transparently displays that all what is required for what is given by the standard setting body we are maintaining it to have and show that onto the respective website. Then there is no need for the regulatory body to poke its nose into the affairs of the institution to go and verify, check. And it is the stakeholder who is observing, who is watching on the website what the institution has claimed, and when they go to the institution, what actually exists. And if there is a complaint against the institution stating that they claim that they have 100 faculty, but they don't even have 50 faculty, then the regulator's role comes in, and probably that is where a very, a punishment of a very high order, which is deterrent to other institutions, should take place. And that is what is there in the new company law. Everything is transparent. Every year, all the board of directors have to give their whatever are their interests also in terms of what type of business they do, and certify every time. And if someone has given a wrong information, fake information, there are provisions to even arrest and put 10 bars. So I think something similar could occur in educational institution, whereby it is self-responsibility. The accountability should be from self rather than being forced upon from the regulator from above.
Thank you, sir. The next question is, what about the foreign universities? How can the Indian institutes be prepared for global competition?
I think let's talk about foreign universities as we talked about for more than 20 years. But so far, formally not about anyone. Informally, some people have some engagements. Officially, both UGC and AICTE have a training program. The student can study some part of the program here and the remaining part of the program in the foreign university, in the foreign location, and can earn a degree of the foreign university. This provision already exists. But foreign university setting up a campus in India doesn't exist. The new policy talks about that as well. If this happens, there will be certainly some provisions in the new act which is going to come up, which has to come up, and through that there must be enabling clause for those universities to apply to Indian bodies, take permission, and then set up their universities in India. The question is, when we talk about
I think there is some.
The question is, when we talk about not-for-profit, some of the Western countries have two different models, and extreme models. Some of the European countries like Germany and maybe many countries around the region, the entire education is free. They don't charge single penny to any student, whether he is poor or rich. And government takes care of.
Thank you so much, sir. I think we have some connectivity issue here. So actually, your voice was breaking. Still, we have one more question that I'll put it to you. The question is, possibly by when this policy will come into force? Sir, can you hear me? Thank you so much. I think there is some connectivity issue, and Dr. Sahasrabuddhe is disconnected due to connectivity. But today we have a very elaborate discussion and the insights with respect to this national education policy. I'm sure this policy will bring definitely positive changes in the existing framework. I think Mr. Sahasrabuddhe, sir.
Huh.
Sir, the last question to you is this: possibly when this policy will come into force?
The policy is already accepted by the government. So policy has started off. See, the components of the policy where you require to change the legal framework will take time. It may take 6 months, it may take 1 year, because you have to formulate the bill. It has to go to both the houses of parliament. There must be discussion and passing of those bills, and then once the president gives assent, it will be in action. But there are many facets of education policy which does not require change in the act. So the question of giving a lot of liberty in terms of flexibility, in terms of formulating national research for foundation and funding to that research, I think many of such categories of actions can be taken care of without any act of parliament. So I think we must start, and the government has already started meeting different stakeholders. How do we implement those reforms which are very, very vital? I had not answered fully because the connection got snapped actually. The foreign universities, when they are given that liberty to apply, so they must be allowed. The only question is whether not for profit, to what extent that will be valid for those, whether what interest they will have come here. And that is the question which is a real $1 million question, number one. And even if they make some profit, how that profit has to be reinvested in India itself, and not they can take it away. I think some kind of regulation may come in the form, and some people may come, may not come. And whoever comes, they will bring in great value, because those institutions which are in the top 500 ranks of the world naturally bring some great benefit, both for our Indian students without going abroad can get a foreign university degree on one side, and secondly, it will also add competition for our institutions, and they will learn best practices of those universities, bring them here, and we can also start competing with them. We have enough talent. It's only that some of the practices, unless we are pushed, we may not be adopting, so we will be pushed to adopt. For example, during pandemic, we were all forced to go online. Otherwise, we were all hesitant to go online. Now this forced us to go online. So similarly, foreign universities coming in, we will start challenging them, and we will be online similarly.
Thank you so much, sir. Before concluding, the last question. The policy particularly pressed on the language, and so far higher education is concerned, and more particularly the legal education. The policy talks about there should be a bilingual education for the in legal education, that is the state language as well as English. So my question is to you that whether this bilingual approach in this legal education will positively impact overall the legal system in this country. Sir, can you hear me? I think we have lost connectivity. So thank you very much, sir. I request Advocate Tanvi Sangre to give vote of thanks. Advocate Tanvi.
Thank you, Pravatak sir, and a very good evening to all. It's my privilege to have been asked to propose vote of thanks on this occasion. So, firstly, I would like to thank Dr. Anil Saharabudhe sir, who has for sparing time from his.
Back to mobile phone.
Yes, sir. Thank you so much, sir. In fact, we were about to conclude. If you want to add anything, you can add, sir.
No, I think this new education policy was long awaited, 34 years, because first policy 1968, then 1986, and now after 34 years. So a lot of aspirations of the people are connected with this. And our Honorable Prime Minister quite often talks about Atmanirbhar Bharat. To really succeed in becoming Atmanirbhar Bharat, this new national education policy is going to be a game changer. And every citizen, whether he is a lawyer or a doctor or an engineer or a ordinary arts or commerce or science graduate, or one who is skilled manpower from class 10, class 12, ITI, diploma, I think each one of us have a great role to play in nation building, and this policy is making that to happen. Thank you very much.
Thank you, sir. Definitely, it will bring very positive changes in overall our country's development, and we will have the same glory which we had when there was Nalanda, Takshashila, and Vikramshila. Now, I request Advocate Tanvi Sangre to give a vote of thanks. Advocate Tanvi.
A very good evening to all. It's my pleasure to have been asked to propose vote of thanks on this occasion. Firstly, I would like to extend a hearty vote of thanks to our guest, Dr. Anil Saharabudhe, sir, who is a professor and chairman of AICTE, for sparing time from his busiest schedule and enlightening us with his knowledge on this very important topic, national education policy and legal profession. Then I would also like to thank all our organizers, Pravatak Pathak sir and Akash Kotecha, for this lovely interactive session. And lastly, I would like to thank all our viewers for joining us in large numbers. And with this, I conclude this lecture for today. Thank you.